Hey everyone, thanks for joining us. We're going to give it just a minute for more people to join in here in the Zoom and the live stream on Facebook. So we'll get going here in 30 seconds, a minute or so. You ready? Hey everyone, my name is Lee Camp. I'm an attorney at Arch City Defenders. Thanks for joining us this evening for, I believe it's our third installment of ACD Live, a live series that's being streamed on Facebook and being recorded. If you're here on the Zoom tonight, where we are talking about different things going on in our world at Arch City and really here in St. Louis. And tonight, I'm here with a couple of my colleagues, so I'll have them introduce themselves, but we're here to talk about what is happening in our local courts in the St. Louis region. And we felt that this was important to talk about because things have dramatically changed, not only in the way that we appear in court and interact with our courts, but for individuals in our community who have court cases or need to access the courts for whatever reason. And we wanted to give a deep dive into what it looks like now, what we're doing, the kind of positives and negative experiences that we're having, and really get some information out to the community about what is happening in the courts right now in the pandemic and what we foresee happening as we move forward. So again, my name is Lee Camp. I'm a senior staff attorney in our special projects unit here at Arch City, and I'll kick it over to Will. I use the he, him pronouns if you have any questions for me.
Yeah, my name is William Waller, he, him pronouns, and I am the managing attorney for the direct representation department of Arch City Defenders. And then Rudy.
And my name is Rudy Angulo, and I'm a staff attorney for the direct representation team at Arch City Defenders, and I use he, him pronouns.
All right, it's over to you, Will.
All right, well, if we can go over the agenda briefly. So trying to hit as many topics as possible. We'll talk a bit about the reopening phases as the courts go from totally shut down to completely reopened like they were before the pandemic. Lee will cover what's going on in the civil courts. And I should specify that this is going to be about St. Louis City, St. Louis County, and St. Charles County. That's what we mean by the St. Louis region. We will also talk about some of the advocacy efforts we've done around specific civil issues. I'll talk about what's going on in the criminal courts and the municipal divisions, the latter being primarily in St. Louis County, where the vast majority of them are. And then Rudy will tell us a bit about what's going on with the family courts. And we'll have time for questions. I believe the chat is open if you want to submit them. And we'll try to keep track of what people ask there, or if you just want to save them to the end and then ask them verbally, you're welcome to do so. Next slide. Okay, so the reopening phases, we go to the next one. At the end of March, when it was clear that the United States was in the depths of a spreading pandemic, most of the courts shut down and tried to figure out what to do now that we couldn't have a bunch of people in courtrooms waiting for dockets and interacting with one another. So the Supreme Court issued a series of orders. I think originally it was in April, and then they updated in July because some places couldn't remain in compliance. But it's a series of phases that courts are supposed to go through in order to determine, based on number of cases in the region, based on cases in their individual courthouses, and based on their health department guidance for each circuit or the county that it's in, and then everyone else involved in the court system, slowly progressing towards more in-person proceedings, less remote proceedings. These are the standards that the presiding judge of each circuit is supposed to consider, because the presiding judge is the one who determines what stage each circuit is in, and starting from phase 0, obviously. Next slide. Oh, so this is the guidance from that Supreme Court order that applies to every phase. The highest one right now is phase 4, and as I said, starting in phase 0. But in all of them, it's expected that even with in-person court, that people will be wearing masks, that people will socially distance, that as many proceedings as can reasonably be conducted this way will be done remotely. And then some stuff which may have made sense at the beginning of the pandemic, but seems a bit quaint in retrospect, like sanitizing common spaces, even though fomite transmission is not much of an issue. And also screening everyone who comes into the courthouse, which they normally do with thermometers. Again, not a very reliable way to identify if somebody has COVID-19 or not, but those will all be with us and for the foreseeable future. Next slide. Okay, so starting with phase 0, which almost everything is outside the courthouse and done remotely, with the exception of what I guess you might call exigent circumstances, like temporary restraining orders, orders of protection, mental health commitments. There's a whole list in the Supreme Court order. And it was very difficult to get into the courthouse. In my experience, you needed a court order to actually get inside during phase 0. Until recently, that was the phase that St. Louis County spent the most time in. And then I think I've covered this, or this was on the slide, but a court is supposed to stay in each phase for 14 days before going to the next one, even if the presiding judge wants to go there right away. So there's at least a 2-week period in between the phase change, and you can go to the next highest phase, but you can't skip ahead. And you can always go back a phase if the presiding judge determines that it's necessary due to, say, an increase in cases. Phase 1 is when you start to have more in-person proceedings. The order says critical proceedings, so it's at the discretion of the presiding judge. It's not clear exactly what that means, but they have a lot of leeway to decide. And there's limitations on the number of people that can be in a given public space. Next. So the third phase is phase 2, which again says you can have even more in-person proceedings, the less critical proceedings in this case, whatever the presiding judge determines that means, and a less restrictive limit on the number of people in one courtroom. And I believe phase 1 and 2, as we'll talk about, is where the city of St. Louis is. The county, St. Louis County, is either in phase 1 or headed towards phase 1. And then the next phase, phase 3, is where St. Charles is at the moment, which allows basically the full range of proceedings that you had before the pandemic, but subject to all those precautions that apply to each phase. And courtrooms can be open, but again, they need to be socially distanced. There's no strict limit on the number of people in a given courtroom. And so you can start to have, say, jury trials again. Next. Okay, so this is the last minute addition because the order came out a few days ago, but now there's a phase 4, which places can work towards, which reflects the fact that there's a vaccine. Again, there's still all those precautions required if you're in person court, And remote court is still encouraged, but they're now, if you're in your own office in the courthouse, you can not wear a mask. Court personnel are now presumed to be coming to work at the courthouse, whereas they might have been remote before, with some exceptions. And yeah, that's eventually, I'm assuming there'll be a phase 5, which is normal. Who knows how long that will be, but right now, as I said, places are somewhere in between phase 1 and 3, as far as I can tell, in the St. Louis region. And we'll talk specifically what that means for each type of case later on. All right, handing it to Lee.
Cool. Thanks, Will. And I think, you really hit a point there at the end that we should probably clarify at the beginning. Everything we're talking about tonight is ever evolving. Even as we put this presentation together last week, multiple changes happened within the past few days in the way that the courts are operating. So, of course, we always invite you to reach out to Arch City or to follow us on our social media channels. If you're working with a different legal aid organization or going to court, feel free to reach out to those courts as well, because this info changes so fast. It is really important to do what you can to try to stay apprised of what could be happening in your potential case. But I'm going to talk about tonight the civil courts. Of course, civil cases are different than criminal cases or your municipal and traffic type cases. These are our, contractual disputes, our collection cases. A lot of what I'm going to spend time on are eviction cases tonight. And these are cases where you don't have the right to an attorney. So particularly if you find yourself in civil courts, it's very important to know exactly what is happening in the procedure that you're in at that time. Next slide, Rudy. So how are these cases being handled right now? Well, I'm going to talk about St. Louis City and County only. And in both of those circuit courts, everything is virtual. So for civil cases in the city and now the county, as of tomorrow, actually, both courts will be using the WebEx platform. If you had been in St. Louis County for any reason prior to tomorrow, you may have used Zoom there in those courts to appear, but now they're on WebEx and you will need to appear. You'll either need to log on with a computer or a smartphone or call into the court if you have a court appearance. If you're not able to do that, we would suggest that you contact the court to make them aware. Particularly in St. Louis County, there is a standing order right now that if you cannot appear by video for a trial that is set, that it has to be continued until you have an opportunity to be in front of a computer. And we'll talk about some barriers that exist. This is a very real problem that we see for our clients and then really just the community at large, is that people are having some issues getting access to video technology right now. If you are one of those individuals, or if you know someone, if you're watching this right now, you know someone in that situation, be sure to reach out to them and make sure that they know to call into the court and make the court aware. I've got both phone numbers for the two courts here in St. Louis City and St. Louis County on the right side of this slide. How do you know where to go? Well, you should be receiving notices from the court that give you information about how to log on to the different dockets at this point. So each judge will have a different now virtual courtroom, the same way that you would go to a different courtroom on a hallway in Clayton or downtown. Now you go to a different website to access the different courtrooms. And in St. Louis City and County, most judges are putting this information on their websites in their judicial profile. So if you log on and search the judge's name, you should be able to find where to go. But you also should be receiving papers. If you are served with papers or you are suing someone, you should receive information from the court that gives you information about how to appear in court. For the most part, because civil cases are not treated the same way under the Constitution, both the Missouri and the United States Constitution, trials are not necessarily happening at the expedited rate that a criminal case would. That being said, there are a few specific types of cases where trials are occurring. Those are particularly eviction cases right now. We know there are order of protection hearings too, and I believe that Rudy's going to touch on some of what's happening related to more things in our family courts, but I know specifically eviction trials are happening remotely, and if the parties are consenting in any type of civil trial to do it by WebEx or by Zoom previous to this, it could happen virtually. Otherwise, most of your big trials are going to wait until a jury can physically come in the courtroom and safely hear a case at this time. Next slide, Rudy. In St. Louis County, to combat some of these issues that we have around accessibility right now, the St. Louis County Court has set up a remote court in St. Anne at Northwest Plaza. And the purpose of this court is the St. Louis County judges recognizing that, our schools have been closed, libraries have been closed, people are not going back into the office or to their workplace in the same way. And for a lot of clients that we serve and for a lot of other individuals in our community, these are their main access ports to get to technology, the very kind of technology that is necessary to participate in a virtual court hearing. So St. Louis County erected this kind of solution to the problem where they have set up different stations in St. Anne at Northwest Plaza where you can go in and set at a court provided computer with a camera and attend your court case. You can file different documents with the court. If you don't have access to a printer and a scanner at home, and you want to get copies of documents that are in the court record, or you need to file something, they have scanners there for you. They have printers to print out those documents. And at this court, you can actually file certain types of cases. I would highly suggest that you contact the court if you want to file something, or if you want to access this technology to appear in one of your cases. I've listed the number here. I think we all know where Northwest Plaza is if you live in the St. Louis area. Again, it's in St. Anne. It's a very large kind of old shopping mall there in that community, and it's pretty easy to find. And it has very accessible hours from 8:30 in the morning. Most dockets start between 8:30 and 9 o'clock in St. Louis County and end relatively early in the mornings or in the afternoons. But this court is still open until 5 o'clock. So you should be able, in theory, to access that court if you do have a pending case right now in St. Louis County only. In the city, I would suggest if you have technology limitations or someone or helping someone advocate for themselves in the courts, contact the court if they do not have video technology to access St. Louis County proceedings right now. These same types of satellite courts and accessibility and remote terminals are just not accessible and available in the city in the same way they are in the county right now. Next slide. All right, so I wanted to spend a little bit of time talking about the housing courts, and this is particularly important to me because I spend a lot of my time practicing and representing families that are going through evictions or training other attorneys to represent people in these cases or working with other lawyers in this area. And we know, based on work that we do day to day, but also stories that we hear from the community and really have heard now throughout the country, that COVID-19 has really presented us with an unprecedented housing crisis. St. Louis City and St. Louis County have absolutely not been immune from the housing instability issues that are plaguing millions of people around this country right now. And so it's particularly important that we prepare people and give information about how to handle eviction cases at this moment. Importantly, both St. Louis City and County are processing eviction cases right now. I have talked to a lot of different organizations and a lot of individuals that have heard this notion that we have a hold on evictions right now in our courts and that we're not evicting people and that there is these federal protections exist to keep people from being evicted. Well, there's some truth in that, But right now, we know every day in St. Louis City and County, there are not only eviction hearings happening, but there are trials happening. And families are having to appear to represent themselves in these hearings. It's crucially important in an eviction case that you do everything you can to appear in court. These cases move through the courts. Prior to March of last year, a case would move through the courts in about 45 to 60 days. Right now, they're moving at about the same pace. So with that being the case, you're only going to have 1 or 2 different court dates that you have to appear, and it's incredibly important that you find a way to at least get a phone call into the court if you are facing an eviction, or if you know someone, make sure they have this information. What has changed in the city and county is while there are trials and there are hearings, up until April 6th, no one is being evicted physically from their homes. You'll notice next week that date comes and will end. We will have families being evicted again that had judgments entered against them prior to March of 2020, but also throughout the pandemic through these virtual hearings. And so if you know anyone that may have thought they had a court date and missed it, it's important for them to check the court records, call the courts, or log on to CaseNet. If you just Google Missouri CaseNet, you can get access to our open court records in Missouri, and Google someone, and you can essentially Google someone's name to find out if they had a case and to see what happened in that case. If you are a tenant who had a judgment issued against you or think that you may have, I would certainly check and keep this date of next Tuesday on your calendar, as we have all indications that the courts will again start sending the sheriffs out to physically evict people from their homes. We are fortunate that we have had protections in the city and county that other Missourians have not had and that others across the country have not had, but those protections do end on April 6th, next Tuesday. Now, there is a federal eviction moratorium that is in place, and I wanted to touch on this for a moment in case you're going through an eviction case right now. That moratorium has been extended until June 30th of this year. That extension happened on Monday of this week. We fully expected that today the moratorium would have lapsed. We were lucky and fortunately found out that the CDC has extended protections for families that qualify as covered persons who cannot pay rent due to the pandemic. And if you want to qualify for that eviction protection, you have to actually opt in, meaning you have to tell your landlord that you believe that you are covered by these protections. These protections do not suspend your obligation to pay rent. They do not protect you if you are being evicted for anything other than not paying rent. But if you do qualify for the protections, and I'll point you on the next slide how to find out about that. If you do qualify, then you need to provide documentation to your landlord. And fortunately, we're hosting that information on our website. Next slide, Rudy. So if you'll see here, this is a picture of the Arch City Defenders website. That's archcitydefenders.org. If you go to our website on the third tab, it's named Impact, and go down to the Housing and Homelessness Advocacy section, you will get this second picture in the bottom right. And we have a link to information about the CDC eviction moratorium. You can find out if you qualify for that moratorium. Again, the main factor being that you cannot pay rent due to the COVID-19 interruption in your employment, et cetera, that you meet a certain income threshold, and that you are trying your best to pay rent or obtain government rental assistance that is available in our community. If you fit those criteria, you're probably covered by this moratorium if you're being sued for non-payment. And there is a form that you must provide your landlord. We've got a link to that form. You can either print it out. If you print it out, you can email it to your landlord. You can physically deliver it to your landlord. For some people, I've said literally fill out the information and send a text message with pictures of it to the landlord. The importance is you have to opt in. You have to provide this information to your landlord or property manager, whoever collects your rent, to be covered by this new protection. And as of next Tuesday, it will be the remaining protection for a renter that is experiencing hardship due to the COVID-19 pandemic. And we will be talking more about this and sharing more information again on our social media channels. And feel free to call our office as well if you have just general questions about if you are covered by the CDC moratorium. And we're happy to get information out to you, as well as you can apply for legal services from someone like myself or my colleagues on this call to potentially help you if you are going through that court process right now. All right, next slide, Rudy. So I wanted to spend a moment. You've heard that we're having remote hearings in the civil cases, and you're going to hear tonight that they're occurring in other type cases, and point out why we have these hearings right now. Next slide, Rudy. So we've had, interruptions and closures of different government buildings and private businesses and restaurants and bars that we've heard about in the community. So it does beg the question, why are the courts open right now? Well, they're open because they have a constitutional mandate to remain open in Missouri. The Missouri Constitution in Article 1, Section 14 says they have to remain open. And it does not say that they can close due to an interruption, by a pandemic such as COVID-19. And that really creates a rub for people. How does the court execute this constitutional command to keep the courts open, but also keep people safe and have, not have in-person hearings? That's how we ended up with remote hearings, which, seems like a solution to the problem. But unfortunately, we know that technology is just not accessible yet for everyone. And if this is the case, and we very much know that it is true, how do we protect the constitutional rights of people that are appearing in court right now? And so we've done a lot of work around this, and we'll talk about that for the next couple minutes before I kick it over. Next slide. So we're seeing positives and negatives, right? As with anything, these civil proceedings that are remote, they do have a couple positives. Civil cases move slow. They move much slower than criminal cases, and we don't have to try them right away. There are not necessarily attorneys representing every party in a civil case. So you don't have the same urgency that comes with getting those cases to trial, sans the eviction cases that have to move quickly based on state law. Another big positive is litigants, people that are being sued or suing someone. You don't have to travel to the courthouse. It saves us time as lawyers to not appear for 15 minutes in the court. We know for our clients, they have to appear a lot for different court proceedings to sometimes just find out, well, my case has been moved another month. And then they have to show back up in a month and wait for 2 hours to find out they have to come back and wait again, a couple months down the road. This has been nice. And we have seen people show up to some of these hearings that otherwise may not participate in court proceedings. But we know and we would argue there are actually many more negatives to these remote civil proceedings. And an important part of this is, our clients really, we notice that our clients, sometimes the worst harms to them happen simply because of procedural mechanisms that exist in the law that take lawyers to navigate. And in civil proceedings, particularly in eviction cases, you're not entitled to an attorney to help you navigate these complex, confusing, and convoluted processes. And so for our clients and the community members that can't access this technology, they're at a decisive disadvantage to participate in this virtual court kind of proceeding. And we really know that a phone call is just not sufficient to call into the court and remain on a kind of crazy and chaotic docket and understand what's happening in your case. And so, with the courts rushing to open, and we did switch between March of 2020 to May of 2020, we went almost entirely virtual. in St. Louis, and really throughout the state of Missouri, to having different court hearings without really considering all of the different accessibility problems that may exist for individuals. And we have seen this particularly bad for those clients that have disabilities, whether those are visual disabilities or hearing impairments. Those have been very difficult to navigate. And then language access issues. In Missouri, you have a statutory right to an interpreter. If you speak English as a second language or don't speak English at all, you have the right to get an interpreter to assist you in going through your court proceeding. It's pretty hard if you're over the telephone to tell the judge why you can't participate in that hearing if they can't see you and you can only speak a different language. And so it's been very frustrating for us as advocates to watch this happen to individuals in the community. You know, sometimes we're representing families going through this, and sometimes we're in court and just watch it happening to countless numbers of families, and pretty disheartening situation to deal with. And then the dockets in civil cases, particularly in what's called associate circuit court for low-level civil disputes, are very large, and they're confusing. They're confusing in modern day court where you can have 100 people crammed into a courtroom, but they're particularly confusing when you have 50 people on the phone and 50 people on video talking over one another, a judge trying to monitor how to mute people and pull people off mute to handle these disputes. It really has just created a chaotic situation. Next slide. So what should you do if you have a civil court case right now? You have to appear. If you do not appear, you risk the threat of a court defaulting you out and saying, we're entering a judgment against you because you simply didn't participate in your case. So you have to make every effort to appear, whether that is by phone or video. If you do need an interpreter, or again, if you're watching and know someone that falls into this bucket, Missouri law requires that you're provided with one, and you should ask for it. Absolutely do everything you can to make it clear to the court that you're going to need help with someone interpreting the court proceedings as they're going on. If you have a disability and need an accommodation, federal law requires that the court provide you with an accommodation for that disability. Again, if you know anyone that falls into this category, help them with these situations, or reach out to an organization like ours for help in these situations. We'd be happy to see what we can do to help you in that moment. If you need to provide documents to the court or evidence, again, work in housing cases. It's not rare for someone to bring me a piece of plaster that fell off the ceiling or a bag of bugs that they found in their home. You need to get those to the court, call the court and ask how you do it. Sometimes they have portals like we talked about in St. Louis County, where you can go and scan those things or drop them off. In the city, you may have to take it to the court, and you need to know the proper processes to do that, and document if you're not able to go through those different channels. And then you can always in civil cases, ask that you come back when the court is in person. We don't know when that date will be. It's tough to even speculate on when we'll actually be back in the courtrooms, but you have every right to ask. And if you don't ask, you never know what's going to happen. Next. So I wanted to touch on, before I end, what we have done at Arch City in response to these different access issues that we've seen. Particularly, we've done a lot of work in what I'm going to talk about, the housing arena. And that was pretty much at the very get-go of this pandemic. When we heard about remote hearings beginning, we knew that we were having trouble communicating with our clients who couldn't just drop by the office, or that we could not go see at their homes. We had to pivot from our normal way of communicating with clients to sending more letters or communicating via email with individuals that could. And we had a challenge. So we knew it would certainly be a challenge to represent those families in court and actually get their participation in these hearings. So we joined advocates across the state, particularly with evictions, and we called for an end to eviction hearings. We did see this happen for a moment, did not ultimately prevail though. As I said, eviction hearings have happened every day, but we continue to call on the courts to stop this process. And at least in the interim, ensure that there are constitutional protections in place for families that are losing their homes during this pandemic. I've often said the best piece of PPE that you can have from COVID-19, is not a mask, it's being able to stay home. And we're talking about now taking people's homes away. So it's very scary, and we will continue to call on a ban on evictions and to cancel these eviction hearings, even in the face of things recovering. As we know, housing instability is a problem that will exist as we recover from the pandemic and as we try to exit it in this very moment right now. Next slide. So what it looks like, other than just saying we called on these things, we've litigated, we've gone to court. We challenged the constitutionality of an eviction hearing for a veteran who was evicted by a phone call. We have filed briefs in support of cases that have been filed, in this case in Kansas City, by a tenant advocacy group there that the ACLU is representing, that was trying to stop all remote hearings and all eviction hearings under the CDC's eviction protections. That case is now on appeal. We continue to monitor it. We'll probably get back involved again there. We have engaged in extensive media advocacy to lift up our community stories about the difficulties that they're having accessing the courts right now. We, have done this through writing op-eds, through just getting our clients connected with media opportunities. And we've hoped to parlay those kind of media advocacy opportunities into making our lawmakers and policymakers, our local judges, aware that families are really struggling, not only with COVID, but also dealing with the courts at this moment. And we continue today to call on policymakers and lawmakers to pass laws and change the way that court proceedings are moving right now in order to protect the constitutional rights of the families that we're working with and the countless other families that we can't represent due to our resource limitations, but also just the need that exists right now for families going through hard times. Next slide. And what we are going to continue to do is monitor things. We're actually launching a court watching program. We did launch this back in the fall to watch remote hearings. We've done this for a long time at Arch City. We've watched Bell hearings and watched the way that the courts, we've kept an eye on what happens in the courts so that we could gather data points to really inform policy and see what's happening. Well, we knew with the shift of remote hearings, we needed to know what was going on. So we started watching eviction hearings, and we watched about 100 different hearings and gathered data around those. And now we're planning to launch a program that will catch the end of these remote hearings and then hopefully go into the physical courts so that we can gather that data and we can make policy, recommendations and reports about what is really happening once we have that hard data. We're recruiting and training attorneys to meet the need and represent families in courts. Our clients that work with me or that work with Rudy or that work with William, they have an attorney that has a computer and can log on. But we know there are so many families that can't get access to these court proceedings right now. If we can get attorneys to literally just go to court for these families, we know that the outcomes could be vastly different for those families right now, particularly who are facing the loss of their homes. And so really, beginning next week, we'll start training attorneys and enlisting those attorneys to go out and represent families that we can't represent at this time because the need is so large. We every day are looking for different avenues of litigation, or policy avenues to ensure that tenants' constitutional rights are protected in these eviction courts. And we will advocate for, changes in the law that reduce the legal system's very role in perpetuating this housing instability that we're talking about right now. And so, we have a lot of work ahead of us to do here. We certainly will keep an eye on this moving forward. But I think that's kind of what I have for you tonight on what's happening in the civil courts, particularly in the housing realm. and I will hand it off to Will to take it over now on the criminal courts.
Okay, so on the criminal side, next slide. Going through the three different circuits, St. Louis City, as most of you know, is its own county and thus its own judicial circuit. And then St. Louis County and also St. Charles County. We'll go through them one at a time, but St. Louis City right now is somewhere between phase 1 and 2, which reading the Supreme Court order doesn't seem possible, but they decided to split it by building. So my understanding is that the criminal courthouse is in phase 2, thus more open to in-person proceedings. And then across the street in the civil courts building, they're in phase 1, which doesn't make much sense since people are going back and forth all the time, but that's how they're doing it. In my experience, attorneys can appear in person at this stage, especially in associate circuit court where criminal cases start out and a lot of them are resolved. Or you can go to the division web pages and find the Zoom information that you need. WebEx information. And that it's not immediately apparent on the website, but you can find it by finding the division pages, much like the county or St. Louis County. They also are holding remote detention hearings. So if someone is locked up on a new case, a new warrant, they have the right to a review of that detention and then another review 7 days later in an evidentiary hearing. The problem is that there's no way for the public to access those hearings. You have to have special permissions. You have to be an attorney in the case. And that is an issue that we fought about a bit, but they are at least holding those hearings, which is a very good thing. And I have it on good authority that they started their first jury trial since March of last year. So I have jury duty next week. We'll see if I actually have to go. Next, St. Louis County, or the 21st Judicial Circuit. Like I said before, they spent quite a lot of time last year in phase 0. I think they've just now moved to phase 1, or they expect to move to phase 1 and then progress to phase 2 now that there's a vaccine and cases are down, although nationally I think they're trending upward. But again, it's based on the locality that the circuit is in. Since last March, I'm not aware of any in-person dockets. I don't want to make I don't want to say there have been none whatsoever because I can't prove a negative, but they have been pretty good about instituting remote dockets on the criminal side. There was a delay from the start of the pandemic where they were just continuing cases because they didn't have remote preliminary hearing set up, which is a problem we'll discuss in more detail later. And they did a good job integrating their detention hearings into those public dockets on Zoom, which is where they have remote dockets. They haven't had any jury trials, unsurprisingly. It's very hard to do that without having a lot of people in one room. And the grand jury was meeting for a while, and last I checked, it is not currently meeting, but on and off. And then we'll go to St. Charles, the 11th Judicial Circuit. So perhaps unsurprisingly for a predominantly Republican county where judges are elected, unlike St. Louis City or St. Louis County, they have been as open as possible for as long as possible. So they jumped right to phase 3 early on with some setbacks where they had to close down again. I know they're the one court that I reliably have to go to in person. And I know they've had issues with people in the courthouse having positive cases. I think the one I've confirmed was in the prosecuting attorney's office, which is in the courthouse, and they did not revert phases as required by the Supreme Court order. I'm guessing their argument was that that person is not court personnel technically, even though from a epidemiological standpoint, that doesn't matter. But they've also had at least one jury trial. I expect they will continue to have them, and the grand jury has been meeting there. Next. Okay, so these are issues that are more or less universal to all three circuits, and we'll go through them one at a time. So starting with the difficulty in finding phase change or current phase information. Go to the next slide. Okay, so that website, which I was on an earlier slide and I don't think I talked about, lays out, it's a map of the state by judicial circuit, and it is color coded to which phase each one is in, and it's updated regularly. So that's the best resource to find out what phase a given circuit is in at the moment. But the problem is, even if you know the phase a circuit is in, you don't know what that means in terms of what kind of court is happening in person, what is happening remotely, how do you access remote court. A lot of that is in the discretion of the presiding judge, and especially St. Louis City and St. Charles have not been great about keeping that information at the forefront on their public websites, for instance. The only information I was easily able to find was out of date, unless I knew to go to the division web pages. But even then, it doesn't tell you if, can I appear remotely? It just says, here's how you appear remotely. The major exception to this lack of information is St. Louis County, where the presiding judge has been very diligent about releasing weekly updates, saying, okay, next week we're in the same phase, here's why, or we're moving up a phase, and here's why in terms of the health department guidance and COVID cases. And actually for a long time, they had a very accessible, like centralized way of communicating information about the associates circuit divisions in St. Louis County and how the criminal cases would progress and were accessed. They got rid of that for some reason. I actually I sent a message to the webmaster and didn't really get a good response why they got rid of it. But as Lee said, go to the division webpage, and that's going to be the best source of information for the associate circuit divisions. Okay. So another major issue, which will require some more in-depth explanation, is probable cause determinations, which is an element in every felony case. Specifically, felony cases can't proceed beyond a certain stage unless there's a finding of probable cause, either through a grand jury indictment or a judge finds there's probable cause to proceed after a preliminary hearing. And it's a whole mess as to which of those happens and why. And I'll try to disentangle it, but the prosecutor really makes the first move in charging a case. They either do it by obtaining a grand jury indictment first, like submitting the case to the grand jury. There's an indictment issued, the grand jury believes there's probable cause, and they vote on it, and then the case is charged for the first time and appears in CaseNet, and things start happening. Or what they do 95 to 99% of the time is the prosecutor charges the case before there's a probable cause determination by filing a complaint. And the reason they like to do that is that you can do it the day someone's arrested, for instance, and you might get a warrant from a judge and a bond that they're held on if you think they're a public safety threat or something. Basically, they maintain a lot more control before having to establish that there's probable cause to proceed with the case. So that's why they charge the vast majority by complaint. And this is exacerbated by the fact that grand jury has been not meeting regularly, and the COVID issues with them meeting in the first place, because it's much like a regular jury. They have to be a bunch of people in one room. And I don't believe they're doing it remotely or haven't made provisions to do that. And then on top of that, you have the preliminary hearing delays where remote court wasn't set up to actually have these hearings reliably, and everyone was still starting to work from home and figuring out how to do remote court. So that meant that a lot of criminal cases stalled out. And the upside was that with everyone sheltering in place and there was less police contact, there were fewer charges issued. So that helped a bit, but only so much. And when prosecutors would file cases by complaint, there was always this requirement in the Supreme Court rules that a preliminary hearing must be held within a reasonable time. Prosecutors could still take the case through the grand jury at that point, but they were now on a deadline, a ticking clock. And reasonable time was always sort of defined by local convention and more or less was 90 days or 3 court appearances in every circuit I'm familiar with. But judges could extend that as much as they want and would be hesitant to dismiss cases for failure to prosecute, even if the prosecutor told them, yes, we have no intention of having a preliminary hearing. We want to send this through the grand jury. And bizarrely, St. Louis County had this initial policy of making defense attorneys set cases for preliminary hearing, even though the prosecutor is the one who has to establish that there's probable cause. Huge mess. Thankfully, now that they're actually having remote preliminary hearings, subject to all the problems that remote hearings cause, and there's this new rule that went into effect this month that actually defines what reasonable time means to have a preliminary hearing. 30 days if a defendant is in custody, 60 if they're not confined, and with continuances for good cause shown. Hopefully that makes it so that we can put more pressure to either get an indictment before filing charges or have a preliminary hearing within a reasonable amount of time, or the judge must dismiss the case for failure to prosecute. But that's something I've fought a lot of battles about, and that we're going to see how it shakes out now with this new rule. Next slide. Lee discussed some of these issues. They apply to criminal as much as civil hearings and trials that are held remotely. Much like civil cases, there have been no jury trials because you can't really get a bunch of people in one room to select a jury and safely have a trial in person. And nobody I've talked to wants to have a remote jury trial, even though there have been a few out of state that I've heard of happening because of the logistical issues involved in that. And there's some issues specific to the criminal side that would make you not want to have one. Specifically, there's issues with in terms of providing evidence to the prosecutor. Normally you take a document and show it to the prosecutor, give them a copy, show it to the judge and the witness. You can't do that. There's no obvious way to do that remotely. You can't really publish it to a jury easily like you can in in-person court. And there's the issue of the confrontation clause. You have the right as a criminal defendant to be confronted by the witnesses against you and to cross-examine them, usually through your attorney. You can't effectively do that remotely in a tiny little video like you can see on the side of the screen. It's much harder to read body language. It's much harder to time your speech with one another and coordinate it. So I don't know of any defense attorney or I know very few who'd be willing to have a remote jury trial. Thankfully, no one's tried to force the issue. But at the same time, you have the issue of people who are confined and want to have a trial, and they're not going to get out potentially until they've had their trial. So you have those speedy trial issues, which I have not encountered that issue personally, but that is definitely something where there's a ticking clock and that they have to have trial at some point. As I said, judges are loath to dismiss cases for any reason. So they're not going to want to dismiss a case for a speedy trial violation. There's also just the general difficulties accessing prosecuting attorneys for negotiation, to deal with discovery issues, because they're working from home as much as anybody else. You're not in a room with them where you can open up your files and say, okay, here's what I've got, here's what you've got, what are we going to do about this? So that just has made resolving all kinds of criminal cases messier. Next slide. Then there's what's happened with the jail population. And unfortunately, we don't have readily available statistics from St. Charles. So this will be about St. Louis City, St. Louis County. As you can see, this graph, okay, you can see the bottom. It starts in 2019 and it goes into 2021. You can actually see a decline in the jail population that precedes the pandemic in 2020. And this applies, or this is the aggregate amount from both the Justice Center downtown and the workhouse or medium security institution on Hall Street. But overall, the jail population was already on a downward trend, and then actually is on an upward trend now. What we have seen is at the beginning of the pandemic, as the CDC pointed out, jails are the perfect vector for the spread of a pandemic, because you have lots of people without a lot of freedom to protect themselves in close proximity to one another. You have a changing population with people coming in and going out. You don't have a lot of access to medical facilities for screening. And they're a population that people, unfortunately, don't care about as much. So if they get COVID, it's very hard for anyone to do anything about it. Especially the city has been particularly egregious in keeping inmates safe. At any rate, that to some extent led to a decline in the jail population at the beginning of the pandemic, when people realized the best thing to do is to let more people out of jail, and thereby also tacitly admitted that these people did not need to be locked up for public safety reasons. To some extent, it seems they've gotten over that, and now the jail population is increasing. There was also that phenomenon I mentioned of people staying at home initially. Less police contact means fewer arrests, fewer cases issued. So I think that was part of it as well. And then we'll go to St. Louis County, which has one jail. Keep in mind that the vertical axis of this graph starts at, I think, 650. The last one was at 0. So that it looks like a much more precipitous decline in St. Louis County, but it's exaggerated in this graph. But there was a substantial decrease in March of 2020 after the pandemic. You can see the drop more noticeably in this graph. And then after that, you see a steady upward climb to where the population is actually above where it was in July of 2019, and is trending upward, as we said. And that reflects that same phenomenon of people understanding rightfully that we should release people from the jail to help stop the spread of the pandemic, to protect inmates, to protect society, and then sort of a normalization effect as the pandemic went on, where things started reconfigured with remote court and such to go back to normal, and for the status quo of a lot of people being locked up to come back. Next one. Okay. So those are some specific issues we've observed in the criminal courts. I want to talk about the municipal courts, specifically St. Louis County, where the vast majority of them are, where the vast majority of municipal cases in the region happen. So a bit about how they've been holding court. St. Louis City, after a delay where everything was getting continued, got its remote court sorted out through WebEx, which I don't think anyone's mentioned. Zoom is like the consumer version of remote meeting space that everyone uses. WebEx is the OSCA approved one that they want everyone to use, even though it's worse. But St. Louis County or St. Louis City has been using WebEx for municipal court since early on last year. And they've, to their credit, have several virtual courtrooms. That information is easily accessible on their website. It's open to the public. You can see the whole docket if you log on to it. St. Louis County, on the other hand, with all the many municipalities in it, each are doing their own thing. Some of them have not had, and we'll talk about this, but they're prohibited from having in-person court. So some of them just have not had court since March of last year. And if you have a case, who knows what's going on with it. Others, either early on or some have just started having virtual dockets, either through Zoom or through WebEx, and are entirely virtual. Some have weird systems like Fluorescent, where you have to schedule a phone call with the prosecutor. At least I don't know what pro se defendants do there. So it's all over the place. It's a mess. And then St. Charles County, as you might expect, has been in person since they could last year, and to my knowledge have stayed that way. So focusing again on St. Louis County, as you might expect, some of them were particularly bold in thinking that the Supreme Court order regarding the phases applied to them individually, and that each municipal division or court got to set what phase it was in. Thankfully, the presiding judge quickly disabused them of that notion and published an order saying that there will be no in-person municipal court until St. Louis County Circuit is in phase 3, which they have not been in since the beginning of the pandemic, and I don't know when they'll be there. And in addition to that, each municipality that has a court that wants to operate in person must submit a safety plan to the presiding judge that must then be approved. And we are trying to make sure that those will be published somewhere obvious on the county's website, so that people who have to go to court once it reopens, have to go to municipal court in person, will know exactly what each municipality is supposedly doing to keep them safe, and can hopefully hold them to account for it. But suffice it to say, no, that hasn't happened yet. Everything is virtual, or it's not happening at all. There's all sorts of problems we've encountered with municipal court, remote municipal court. One of them is just that the public can't access remote court dockets. Either it's a situation where if a member of the public did have the Zoom or WebEx information, they could get in, but that isn't published on the court's website. Some don't even have websites. Or it's in a specific notice sent to that defendant, who may or may not live at that same address from the beginning of the pandemic, especially if they've started remote court later as the year went on. Sometimes you can get it on CaseNet if you're an attorney. Like, I can pull it off my client's case on CaseNet. Sometimes that document isn't available to me as their attorney. So, and you just have to call and hope you get a clerk who will tell you or email you that information. Moreover, even where you can get on to Zoom or WebEx, what a lot of courts are doing is they have you in a waiting room, and then when your case is called, so to speak, you go in a private room with the judge, probably a clerk, maybe the prosecuting attorney, maybe not, and your case is dealt with individually, which has some benefits, I suppose, but is certainly not in keeping with this statutory requirement that Missouri courts be open to the public, and that people can freely attend them, or the court operating standards from Senate Bill 5, which is that next statute. And there's a reason we want municipal court to be open to the public, because that sunshine is a sort of disinfectant. I find judges are on better behavior when I'm doing things openly, rather than when you're with them individually and no one else is looking on. And as I said, some places just don't have dockets at all. which if you've had a case pending since before March of last year, there's no obvious way to figure out what's going on with it. Maybe you can reach a clerk who will explain it, maybe you don't. But if they just decide to have remote court after a year delay, and they send that notice to appear or you'll go warrant to your last known address, which you no longer live at, you can see the obvious problem with that situation. Or you called them in April of last year, and they told you we're not having dockets right now. And how do you know when that changes? Next slide. Similar to the criminal situation, but sort of worse in municipal court. A lot of what you do in municipal court is you try to get an amended, the charge amended, so you avoid points on your license, you avoid having something on your record, and you do that by negotiating with the prosecutor. And if you have an attorney, now we can do that remotely probably, although not always. But if you were, like the vast majority of people, unable to afford an attorney for municipal court, you would normally go to court and the judge would say, okay, get in that line if you want to meet with the prosecutor. There is no clear way to do that for the most part for pro se defendants with remote court. There's an exception. Some places actually have a separate docket you can access where you meet with the prosecuting attorney during normal court. And some even let pro se defendants do that. So that's one solution, but it's certainly not a universal one. There's also this obvious issue of missing remote court and having a warrant issued for your arrest, combined with the problem of not having readily accessible information about how to access these remote dockets. Surprisingly, I have not personally observed this happening. I think maybe once I've seen it, but it's certainly threatened quite a bit. I have no doubt it's happening. And in compliance with Senate Bill 5 and the new rules, they're sending out these show cause orders when you miss court, again, to your last known address. But these are the standard ones they've always been using that imply an in-person appearance is necessary, at least in some cases, which is even more confusing and problematic. A lot of this comes down to the lack of standardization and the lack of publicly available information across all municipalities, which is a problem you encounter repeatedly with the fact that there are 60 to 70 some municipal courts in St. Louis County that all operate independently, or municipal divisions. Other remote court issues, obviously technology is an issue. You say you only have a phone, you don't have a computer or one with a web connection or microphone. You can call into WebEx, which can be difficult to figure out. But then you're at, if you're addressing a judge over the phone with bad reception, you're at a substantial disadvantage to somebody that is actually face-to-face with them. And obviously some people have problems with technology, like how to access these things, even if they have all the technology they need to do it. I had very bad internet, and night court was a total crapshoot for several months for me even, and I can't imagine as a pro se defendant how to navigate that if I was in that situation. So, and another huge part of municipal court is compliance, showing you have insurance, showing you have your license reinstated, and there's no obvious way to do that remotely, and no clear way to get that information to the prosecutor or the court to accomplish what you need to do. Next slide. I mean, we could go on for days about municipal courts, but this should be the last round of issues. One thing we've seen a lot is people appear for remote court, or we appear for people, and the judge wants a waiver of the right to appear in person. And they want that signed and submitted in order to appear for remote court. But the way they communicate with these notices, to the extent you actually get them, is like, you must appear or you will go warrant. And then you appear and suddenly you should have submitted this waiver of your right to appear in person. And there's nothing about the reciprocal right to have in-person appearances. Obviously, these courts are about collecting money from people and funding their respective cities. So they want people to appear remotely and to force them to resolve their case and pay their fines. And so there's nothing, I've never seen an indication that people that would alert someone to the fact that they could say, no, I don't want to resolve my case until the courts reopen in phase 3, however long that takes. I've never seen anyone informed of their right to do that. And then this is an issue that was a problem before the pandemic, but has certainly been exacerbated by it. And it's the fact that there's no standardization for where you find information about your cases. I believe there's still places where you have to actually call them, and that is the only way to find out if you even have a case or what its status is. There's no database where you can access it. A lot of them were on municourt.net. St. Louis County Municipal Court had its own website where you could look up cases. You could find some through Regis. Some courts had their own database on the website. But the St. Louis County presiding judge ordered back in 2018 that by May 1st of 2019, everyone needs to be on CaseNet and everyone needs to accept e-filing, which for attorneys is something that makes our lives a lot easier. And they're not all in compliance to this day. It's been almost a year since then. No, almost 2 years, I'm sorry. And there are still places that do not have their cases on CaseNet, and there are still places that do not have e-filing implemented. I don't know why they're not held in contempt, but they should be. And others split the difference. They have all new cases after a certain date on CaseNet available for e-filing, but their old ones are in some other database or not available at all. So you can imagine as a pro se defendant navigating this is an enormous headache, and a lot of people can't bring themselves to deal with it. Next, okay, I'm going to turn it over to Rudy to discuss family courts, and then after that, we will take questions.
Hey everyone, I'm going to briefly touch on some of the issues that have been happening during the pandemic with the family courts. Obviously, there's a huge overlap in what's been happening with what Will and Lee have been talking about, but I did want to bring to light a few key issues and just give some background on what's been happening. So at the beginning of the pandemic, most cases were at a standstill. So you had basically cases that were set for status conferences under divorce or an update on a custody case, and those just got delayed indefinitely. The one thing I'm aware of in St. Louis County is that even during phase 0, the court was still physically open for people that needed orders of protection. So this was vital in people that were experiencing domestic violence, that they were able to still go into court, get in front of a judge, and get their order of protection issue heard. I had several clients that were able to do this and access the court that way. And really throughout the entire process, that's been one of the most open areas of the entire court, and one of the areas where the court has worked the most with both attorneys and with self-represented litigants, and being able to get those orders issued. Then really what started happening is that while certain courts started to go virtual, other courts in more rural areas just started opening up. So this, St. Louis City and St. Louis County began to reschedule their normal hearings via Zoom, St. Louis City via WebEx, depending on the case. Whereas some of the cases that had more rural Missouri, I would just call them and they say, nope, we're open, we're ready to go. So you had to do a little bit of a balancing act with clients and saying, do you want to physically go to court where there's a high risk of you getting COVID, or do you want to ask for a continuance or maybe set this out at a later date when maybe we can either do this virtual or we can do this when there's better safety protocols in place, or maybe once everyone's been vaccinated. But of course, this causes a lot of issues because some people want to see their case progress, and so even though they understand that there's a pandemic happening, especially if it's something related to custody of children, they really just want to expedite this case and do everything that's possible to get a court date and to get their case resolved. One of the things also that I noticed that I was able to do was, for example, in St. Louis City, before some of the cases were being heard virtually, is I was able to actually just call and speak to a judge and say, this is a case that I have pending. Is there any way that I can resolve it? And I would be able to resolve it that way. But that's kind of a unique thing that you have as an attorney, is that privilege that you're able to call and speak to a judge, where it's something that's very difficult to do if you're a pro se litigant or someone that's representing yourself in court. So the big issue was visitation. This truly became a problem at the beginning because there was a sense when the pandemic started that it was going to be a few weeks. And so you had sometimes custody orders where a parent said, well, my child is with the other parent. There's this 2-week lockdown order that obviously went a lot longer. And so what happened is a lot of attorneys just kind of said, well, let's keep the child there for the time being. And then as time goes on, let's go back to the normal custody order. This caused a lot of tension and a lot of issues with parents when maybe one parent felt that it was safer for their child to stay with them throughout the duration of the pandemic. And obviously that causes problems because the other parent wants to see their child. So there was a lot of back and forth on that. And it really caused courts to start weighing, what's best. Is it better for the child to be not possibly exposed to COVID, or is it better for them to have a meaningful relationship with both parents? And obviously this was very unique on a case-by-case basis, and it really varied from judge to judge. And really overall, just like with any other family court issue, there was a kind of a weighing of factors done and determinations as to who should be seeing the child. But I have seen some pretty egregious cases where parents were essentially denied visitation of children. This was more of a situation where a child was in a guardianship type situation rather than being with another parent, where the court would kind of err on the side of saying, they're with a guardian, let's just keep them there until the pandemic is over. And then you would basically have parents who haven't seen their child for 6 or 7 months that are just getting desperate because in a lot of cases, not only are they being denied physical visitation, but the guardians are really not putting forth any effort to do any kind of virtual visitation either. One of the other situations was visitation where the parents are trying to regain custody from the state. So this is what you call a child protection case, or a case where the child is in protective custody because there has been an allegation of abuse or neglect. And so the parent is essentially working with the courts and working with Children's Division to regain custody of their children or child. What this looks like in most cases is that, depending on where you're at, you could be in a situation where you are gradually increasing your visitation. And in a lot of these cases, that is through increase in supervised visitation. So since supervised visitation in a lot of cases happens through the courts, what happened is that the court said, well, we're going to issue a new visitation order where it's all virtual. Again, this might have been a good solution if the pandemic hadn't lasted as long as it did. But what we're seeing is that cases where visitation or orders were still being issued saying that the cases or the visitations should be virtual, you still have those orders in place, and you still have judges who are agreeing with orders saying, okay, let's continue this, let's let these visitations be virtual, when in reality, what this is doing is breaking down that parent-child relationship, where it's essential that the parents be able to see their kids. And you really have to do that whole thing again of weighing, especially now that this has gone on this long, is it still fair to keep the parents physically away from their children when they're not seeing, they're not being able to see them in person. And then more than anything, what I've seen is in some cases, that breakdown in the parent-child relationship is actually being used as one of the factors to say this parent should lose their rights over their child. Let's file for termination of parental rights, because Missouri does have this 12 out of 15 months. So if the child's been in protective custody for the past 12 out of 15 months, with some exceptions, then the state can file for termination of parental rights. And really, what I've advocated for in my cases is that we should really be lenient on that, because we're in a different type of situation here where the parent hasn't been able to see their kid, and they really need that extra time to reestablish contact with their children and to reestablish that parental bond with them. So some of the things that I've seen the courts doing right recently in these types of cases, first of all, is allowing parents to show up to court, even though they're going to virtual court, they're actually physically showing up to a virtual court location. I know that either Lee or Will mentioned the St. Anne location, but I was also told by a St. Louis County judge that if a parent had issues with technology, they could just show up to court in St. Louis County, and they would be placed basically in a booth with a computer where they would be able to access the courtroom virtually that way, and they'd be able to be there in court. Because this is another thing that's been happening in some of these cases, is that you have a hearing to check on the status of the custody of the children, and one of the parents has technology issues, and they just can't physically be there in court. And so obviously it's extremely detrimental to someone's case when they're fighting for the custody of their children, when their voice can't be heard in court. So the other thing the court is doing right is being cautious about phase transitions, especially I think St. Louis County and St. Louis City has done a good job of that. Even though there are issues with it, the ability to protect court staff and attorneys and parents is definitely appreciated. And then just really continuing to adjust procedures for more ease of access to court. I think this is going to be important, especially moving forward, where perhaps some are vaccinated, some are not, and there really should be a lot of leeway into how you allow parents to access the courtroom. And then improvements yet to be made. This is all across the board with every court: consistency. If I notice consistency as an attorney, I can only imagine people that are trying to represent themselves in custody cases and dissolution of marriage cases, how hard it is for them when one court is doing something one way and a different court is doing something another way, and then you think you're doing it the right way, and the next thing you know, your case is being dismissed because of a procedural issue. And again, that kind of goes into my next point, that there needs to be increased access for self-represented individuals. This actually goes beyond just the pandemic. I think that it's just an extremely hard hurdle to get past if you're a pro se, self-represented litigant that's trying to work on a family law matter. And I really think that we need to put more resources into thinking about ways that parents can have an opportunity to have safe visits with their kids. I mean, as far as I'm aware, still many cases where parents are not getting to visit their kids because either St. Louis County or city says we're not in an operating phase where we can have people in court, we can have these visits. But there really should be some ways to go about saying, okay, well, we also can't deny the parent visitation for this long, so we need to figure something out. And then really just my last point is hoping that judges take an active role into not pursuing termination of parental rights cases due to breakdowns in parent-child relationship during COVID. I mean, that there really needs to be an inquiry into that, saying, have we really taken the reasonable efforts to reestablish this relationship despite what's been going on, and to try to get some of these in-person visits and kind of relax that 12 out of 15 month rule. And I think that's all I have on family law. So I'll kick it back to either Will or Lee.
So now's the time for questions. We've got about 6 minutes. There's one in the chat I wanted to address first before anyone else weighs in. But it says, have attorneys at ACD been in contact with the prosecuting attorney and or the mayoral candidates? I can speak to some of this, but I know that as an organization with a lot of people doing a lot of different things, we've been in consistent contact with policymakers, with people in the current administration. I don't know about candidates, but certainly we've been heavily involved in advocating for inmates in the jails, especially the city jails right now, with the resistance that's going on there, and the COVID issues and such going on there. We're also a member of the prosecuting the Prosecutor Accountability Table, which is a coalition of similarly aligned groups that advocate for, well, in our case, abolition, but generally reform of prosecutor practices, and have been in conversation with both Wesley Bell and Kim Gardner. That preliminary hearing issue I mentioned earlier is my personal pet project at the moment. But so yes, we try to have as much contact with people who have power to affect these things as we can, whether they'll talk to us directly or we have to agitate and advocate externally, because they won't. So I don't know if there's a way for people to ask questions verbally, or if people want to submit them in the chat, we will see them. But we'll hang out and okay, submit in the chat is the word. So if you do have a question on anything we've talked about, anything Arch City Defenders does that we might be able to speak to, go ahead and put it in the chat, please. Oh, there is a question and answer function as well. Okay, so question is, are you all working remotely or in the office? Our office has been closed down. Oh, Lee would like to answer this question.
I was just noting that it would be, you go.
Okay. Our office has been shut down since March of last year. We personally use it to the extent we need to, but we try not to gather there, and it does not have, it's not open to the public, unfortunately. We would like to reopen it because that is a way a lot of people access us, a lot of our clients. We want to be able to meet with our clients again, but until it's safe to do so, it remains closed. You can reach us at that general number through our individual emails, which are all at archcitydefenders.org. There's intake at archcitydefenders.org for if you personally want assistance, or what I would recommend instead of that is, because this would probably be the response, is to go to our website and at the top it says how to apply, and there's an electronic application if you want our assistance on a specific thing that you can complete there, and we'll get back to you. So we try to be as accessible as possible, but no, our office is not currently open to the public. So there's someone thanking us for court watching efforts from a volunteer who just started with the court watch and is looking forward to things getting back to normal. Yes, so are we. I don't know, Lee, if you wanted to talk more about our court watching. I know you touched on it during the presentation.
Yeah, I mean, we fully plan to launch a more robust eviction court watching program. There's not been anything like this in Missouri. There has been some work similar in Kansas City, but we are really wanting to get it going for the eviction courts again, while they're remote and moving out of it. We know that it's terribly difficult to get data about the outcomes of these hearings and to know what's actually happening. And of course, hard to make policy recommendations and, tell the stories of what's going on in the courts without knowing everything going on. And so that should be launching soon. On our website, we have information about how you can volunteer with Arch City and et cetera. definitely would direct you there, archcitydefenders.org. If you go to our Facebook or Twitter, any of that stuff, that contact info is there. We're kind of an open funnel. If you want to get in touch with us, if you want to volunteer, if you're interested in, the landlord tenant work, and if you're an attorney watching this and want to volunteer with us, you can certainly reach out. Again, through the website's the best, but yeah, we're interested in getting volunteers to work on this, particularly with housing. We have a deluge of evictions that are going to not only hit the courts, but really could wreak havoc on our community. And any way that we can get people plugged in to help, we will take the help right now. It's desperately needed.
All right, well, I think we're just about out of time, so last minute questions if anyone has them. Otherwise, I think we will finish up. All right, well, it's been a pleasure. As you can see, our contact information is there, and we appreciate everybody who tuned in.
Thanks, everyone.